Thanks for pointing that out to me, Brad. Thank you.
That's okay.
Yes, somebody else wanted to say something. Erin?
Manjo, Theron here. I'm having great difficulty in understanding you. There seems to be a problem with connections. You're dropping in and out.
Oh. Okay. Yep. Is everybody else, are most of you experiencing the same problem as well? Am I kind of dropping in and out? Not the others.
Yes.
Dee is shaking her head.
Yes,
Some are saying
Manjo.
yes.
Yes, Manjo, you're dropping out my end as well.
Oh, I'm not sure what I'm supposed to do.
We were wondering if it's because you're getting too close to the mic when you're speaking.
Okay, good. I might be. Okay, thanks. Okay, that might be better. And I wonder how I look if I do this. Oh, that seems to be better. Is that fine? Can you hear me?
Yes, that's much better. We don't really mind how you look. We just want to be able to.
Yeah, I might actually end up shouting to the mic, which wouldn't be pleasant for you. Okay, good. So this is probably
That's okay.
I was too close. I'm actually using a notebook computer. That's why I felt like I had to lean in because the keyboard is in front of me. I'm using a notebook this time, but this should work. Okay.
Maybe not so far away, but just not so close.
Okay. Thanks.
And Manjo, can I just comment on your thing about footnotes and putting explanations in there?
Yes.
In previous courses that I've done, some of the lecturers have actually said that if you just include the citation, that's fine. But if you include additional information, they will count that towards the word count.
Right.
So not every lecturer will approach that in the same way, I just should say.
That's right. Having said that, you will notice that I did indicate in the legal memorandum assessment that footnotes were going to be excluded from the word count. So therefore, that would have given the signal that you could make good use of the footnotes to provide an explanation where you wanted to. And
oh yeah. Yeah, no, that's okay. I was just letting students know that's not the general consensus though.
No, that's right. That's right. Yes. That's
Manjo,
right.
didn't it say footnotes were excluded, but any substantial text would be included?
Sorry, what was that again?
Didn't it say, I could be making this up, but didn't it say that the footnotes were excluded from the word count, but any substantial text in the footnotes would be included?
Did I say it there? Probably not. No.
I can't remember if you did or not, but generally that is has been
that's
been
right.
the rule.
That's right. Yeah, but as I said, so I'm sure I did put it there because that's not a language that I would normally use. And I don't think I have actually used that language. And so it depends on the lecturer. But having said that, I'd like to point out, as I said, that I just decided to put as much footnotes as I could, mainly because I wanted that to be a guide to students to kind of refresh their memories about administrative law. But I was certainly not expecting that level of detail in your, in the answers of the students. So in fact, as you notice, about 10% of the cohort had marks of 90 or greater. And you can be sure that if you look at the exemplar answers, the kind of detail that they went into was not as much as I had put into the model answer that I made. But so as I said, I came up with a. Sorry, what was that? There's something wrong with what's that? Nope. Nope. Wait, who's that? Jacob, is that you? Okay, I'm gonna have to mute all. Wait, so I've had to mute everyone because I think somebody was trying to say something, but I couldn't hear what that person was saying. I think that was Jacob. Yeah, Jacob. Hey, Jacob, you have to get off the helium though. Spread corpus, get off the helium, Jacob. Yeah, because you do sound like a child. Okay, hold on. Wait. Jacob, there's something wrong with your mic. You probably need to use the chat box because we couldn't understand you. Okay, but for now, Jacob, you can't use the mic for now. Is that Jacob or is it somebody else? Okay, Jacob, please refrain from using your mic because we can't understand what you're saying. Now, would there be anything else before we start talking about judicial review remedies? Anything else?
Manjo,
Yes.
I just wanted to ask if you were getting marking assistance for the take-home paper as well.
Yes, I am.
Can I just ask then, do you mark the opposite ones that you didn't mark in the assignment, if that makes sense?
Okay, so in other words, those that I did mark in the legal memorandum, I'll mark them this time. Is that what you were suggesting?
Yeah, I guess just so it kind of evens out a little bit. So the half of the students who were marked by the assistants then in the take-home paper get marked by you and vice versa?
I see. Possibly that can be done. I could do that, except that I'm only allowed, well, I can only mark 30 because I'm getting marking support for 70. So we've got strict rules kind of in the university where, you know, based on the EFSL, a course coordinator cannot be loaded with too much work. I think it has to do with the employee enterprise agreement. And for that reason, I've been provided marking support. So I could mark 30 papers in the final assessment. Those final papers will be the ones whom I did mark for the legal memorandum assessment, but there will still be 40 others who will not get marked by me, both in the final written assessment as well as in the legal memorandum assessment. So what I'll probably do is to just kind of mark the 70 randomly to kind of even the odds. Yeah, instead of doing it in alphabetical order, I'll mark the 30 of the 70 that I did mark for the legal memorandum and mark them randomly.
I think that's a very good point that Melissa brings up there, Manjo. We go through this course for a 12-week period, and you learn the sort of the idiosyncrasies, I guess, of the lecturer, what they like, what they expect, even issues, for example, what you've just mentioned about the footnotes, and then somebody else marks them and marks you differently to what the lecturer would mark, and it's extremely frustrating for a student. Because you go, okay, well, I expect I've done this. I know teacher said to do A, B, and C, and you go and do that, and somebody else turns around and says, well, I want E, F, and G, bad luck. It's you know, that's where a merits review would have.
Something is wrong with your mic this time, and I think I'm not the only one noticing you. But you're right. I got the point, and I find that really valid. So I'll see what I could do. I could probably mark more than 30 anyway, and leave the rest to Chris to do the marking. But I do moderate the markings of Chris because that is the rule. So before I release the results, I need to be able to go through what this mark, for example. And so I usually choose about 10 to 15, even to 20% of what you mark, and just go through what comments you may have made or the marks you may have given. And I'll do that more for the final written assessment, in the sense that I will likely moderate more of what Chris would have marked, just to see if I am in agreement with his marking. But I'd like to point out as well that on the one hand, I tend to be more liberal in terms of giving good grades, where I feel that there has been a genuine effort and the answers are really good. But on the other hand, I tend to be very conservative when it comes to marking if I feel like the student didn't put too much effort. So that's the bad part there. If I'm unhappy with the kind of effort I see the student putting in, because the student has mainly been regurgitating what's in the notes without even trying to connect the legal principles that have been cited to the case facts, I get really disappointed and frustrated by that, because I know there hasn't been any genuine attempt on the part of the students to really address the legal problem. So let me repeat that. So if all the student does, or what the student does mostly, is to just restate legal principles or case law without trying to use what has been written or stated in the legal memorandum or in an assessment and trying to draw a connection of the case facts, that is absolutely frustrating for me, because it doesn't tell me anything that the student has contributed. Remember, the contribution of the student here is really drawing the connection between the case law or facts or the case law or principles that have been cited and applying those to the case facts. That is the initial contribution. So if all that happens is just a citation of case law or legal principles, it really counts for nothing because it's an open books assessment. So the initial contribution of the student will have to be to apply the legal principles or case law to the facts. Secondly, the key task for the student is to really use that discussion as a way of arguing a conclusion. So that discussion, so the way that you apply case principles or case law to the facts, that's the initial step, that's the application. But you then use that discussion there, the application of case law, to lead to a conclusion. It must lead to a conclusion that answers the assessment task or that answers the legal issue. If all you do is have a discussion, apply the case law, but you then do not try to address the legal problem, it means nothing, because it's like you're trying to draw case law and case principles and the facts, but you're not giving an answer to your client. At the end of the day, your client is coming to you because he or she has a legal problem. That's why the client is there. So if all you do is to lecture the client about what the law is, it's nothing. The client doesn't appreciate that. He doesn't understand what's going on. So at the minimum, he wants you. Yes.
Do you think maybe it's because as law students, perhaps we're a little bit worried about drawing one conclusion or another? I mean, it's always nice to be able to say, I'll just go and talk to my colleague and then I'll come back and
Yeah, but that's the beauty of it, because although in a sense you might say that when we design assessment tasks, we have a ready answer in mind, we know what the logical conclusion is, but in truth we're actually open to contrary answers, something that surprises us. That's not a problem, for as long as you can defend it. So if you present a well argued piece, even if it's not something that I would have expected, it can easily get a high distinction mark, even if it's not what I expected, for as long as you've actually gone through the process of citing the proper case law, connecting the case law or the principles to the facts, and then on the basis of your discussion, you come up with a persuasive argument that leads to your conclusion. So remember, the discussion leads to a conclusion. That conclusion is actually the answer to your client's problem. So, and it's possible that you can end up with a different answer altogether. That is fine, as long as you were able to cite the appropriate case law, have the discussion, and on the basis of your analysis of the case law and the facts, it leads you to a correct conclusion. If we could see the trail of logic there, that is perfectly fine. Even if your conclusion is different, you will get 100% credit still.
I'd just like to ask whether it's going to be another legal memorandum. Will the final exam be another just one question legal memorandum?
It will still revolve at least around 5 case problems. It's possible, when I say legal memorandum, it essentially means that you've got a different interrelated sets of facts, but revolving around the same parties, and then there are some legal issues. I haven't quite decided yet, actually, because I'm trying to see what happens during the revision. But what I can tell you is that the final written assessment will be very much kind of like the tutorial problems that we have. So if you listen to the tutorial problems, listen to the tutorial sessions that we have and go through these suggested model answers and closely examine the kind of problems that I have created, in all likelihood, the problem questions that I raised in the final written assessment will be similar to what we've covered. So it won't be something that's totally new or that is new. So the questions will be kind of an expansion of what has been previously discussed. So there will be a lot of similarity between the final written assessment questions and the tutorial problems that we've had. Okay, what time do we have? 7:40. I think we should move on. Now, as I said, I have difficulty looking at the chat box. So because I can't answer questions that were stated using the mic and then read the tutorial, the chat box at the same time. So I'll try to get back to what is written in the chat box later on. But if you feel like you really need me to answer something, you're going to have to flag me by using your mic, because otherwise I'm not going to be able to read the chat box. But having said that, I think we need to proceed because we're kind of running out of time. So tonight we're going to be talking about judicial review. But I mean, feel free to flick me an email if you have further questions anyway. So for tonight, we're going to be talking about judicial review remedies. And after studying this topic, you should be able to discuss and explain the distinction between common law prerogative judicial remedies and equitable judicial review remedies. The specific common law prerogative judicial remedies of certiorari, mandamus, prohibition, and habeas corpus. The specific equitable judicial remedies of declaration and injunction, and the statutory judicial review remedies. So we have two tutorial problems for tonight. So we've got problem 28 and problem 29. The one for problem 28, I think, is a bit more complex. I'll delay that. Instead, I'd like us to cover problem 29, which is less controversial. Can I have a volunteer who can read problem 29 for us?
My mic work better now? Can you hear me better now?
I could. And that would be?
Jacob.
Jacob, yes, go ahead, Jacob. I could hear you, Jacob. Thank you.
Excellent. What's that? The problem 29. The Franciscus Mills Proprietary Limited. Francois, sorry. I'm Italian, I'm not French. The Francois Mills Proprietary Limited applied for a broadcasting license with the Australian Broadcasting Agency, ABA, and to be allowed to post a bond of $500K for the license. Under Section 43, Paragraph A of the Australian Broadcasting Standards Act, Commonwealth, a broadcasting license shall only be issued by the ABA upon payment of a bond of $5 million by an applicant for a license. Section 43, Paragraph B of the Act also provides that the ABA board has the power, which it may or may not exercise, to reduce the amount of the bond required under Section 43, Paragraph A of this Act. The ABA refused to issue a license to Francois Mills Proprietary Limited until it posted a bond of $5 million. Francois Mills Proprietary Limited has approached you as a solicitor for advice. Advise the company on the judicial remedy or remedies that might be available over the ABA decision.
Thank you, Jacob. If you could, can I just ask you, all of you, or most of you, to post your answers in the chat box.
Hey, I've never been able to cut and paste things into this chat box. Is there some sort of trick to do it? I try to, no, it's okay. It's just, okay, I'll work it out myself then.
Okay.
All right, I'll go away and I'll work it out.
Okay.
I have no answer, by the way.
Okay. So I've gotten something from Jason, B, mandamus, Margie, mandamus, perhaps. So from Vivian was the impact and discretion. So good answer from Chase. Quite long though. No. Damas.
Yeah, sorry, Manjo. I had to copy that in about 4 different sections.
Was there more?
Yeah, I think so.
Okay. Oh, this is quite long. Oh, there's an injunction. So Jason,
You can check. You can check my IRAC method while you're going.
Okay. Okay. Yep. So from Jason, you've got certiorari, you've got injunction, and so on. Well, there's a lot going on in the chat box, and we don't have the chat. We don't have enough space to put everything in on the screen. So there's some are saying injunction, some are saying certiorari, some are saying mandamus. Okay, good. Wait, am I missing something else here? Okay. Okay, so we got we've got possible different remedies here that have been cited: mandamus, injunction. We've also have certiorari as well. Now, before we discuss those, I wonder if we might have missed something crucial here. Before we start talking about remedies, I wonder if we might have missed something very important. So from Libby, however, there is a discretion. Some are saying jurisdictional error here. Is there so from Libby, is there an error of law? Libby, can you tell us why are you raising that point if there's an error of law?
I raise that point because in reading the question, it appears that the enabling legislation provides for the payment of the $5 million bond, and then it says under section 43B that the board does have the power, which it may or may not exercise to reduce the amount of bond. So that appears to give the board itself ultimate discretion as to whether they choose to exercise the power or not. And so in choosing not to, arguably, there still has not been an error of law.
Therefore,
it would mean that it would not be justiciable under judicial review. Potentially a merit review if the Act allowed for it, given that the tribunal have the power to stand in the shoes of the original decision maker.
Okay. So, as correctly pointed out by Libby there, before we even start talking about remedies, possible judicial remedies, we need to figure out if judicial review is available in the first place. So that is a crucial point. Because remember, if you talk about judicial review, you need to find out if courts actually have jurisdiction in the first place. You don't just talk about remedies. So I think for most of you, you may have missed the point there. You may have jumped the gun. You need to find out if there is, if judicial review actually is available in the first place. It would appear, and remember, we need to know whether or not, and the only way we can say that judicial review is available is if the problem involves a question of law or involves an illegal act. As pointed out by Livy, there is a discretion on the part of the ABA. That's one. And secondly, it appears that when the ABA exercised its discretion, they decided actually to insist on a payment of the bond of $5 million as provided by the law. So if that is the case, the question is, did the ABA commit an unlawful act, or was their decision therefore illegal or unlawful? Because if it did not involve a question of law, if the ABA did not commit an unlawful act or an illegal act, then judicial review is unavailable, and therefore we shouldn't be talking about judicial remedies. So, having said that, would anyone wish to say something?
Yeah. What if
Yes.
the decision was unreasonable?
How can you argue that?
Well, 5 million's a bit excessive. You could argue that it's oppressive or capricious, or perhaps the Wednesbury unreasonableness, and then perhaps the court could look at equitable remedies, maybe.
Who was that?
Audrey.
Audrey, thank you, Audrey. Now, when you say yes.
So, sorry, Manjo. I was going to say that my response to that would be that the question of, is the decision so unreasonable that no reasonable decision maker could have come to it, could be answered in the affirmative, given that the legislation clearly states that a bond of 5 million is actually the first and foremost bond, and that anything other than that is at the discretion of the board.
Okay. I'll go back to that, Libby, but I'd like to address the point of Audrey. And remind me to go back to your point, because it's actually relevant. Audrey, when you said that potentially you can raise the notion of Wednesbury unreasonableness, which one was unreasonable there? Was it the legislation, or was it the decision of the ABA that you found unreasonable?
Well, it would be the decision of the ABA. Is that right?
Okay, good. So let's just clarify. So if the law, if as a lawyer you found the law to be unreasonable, would that then possibly be used as a way to ask for a judicial review of a decision based on an unreasonable law? Let me repeat. If you have a decision by an administrative agency and you assert that the decision of the agency is unreasonable because it is based on an unreasonable law, is that a ground for judicial review?
Yes.
Okay. So let's be clear that as far as administrative law, you cannot question the legality of a law itself. That wouldn't be part of judicial review. That can be part of, the power of the courts to examine the legality of legislation, but that would be constitutional law. That will not be administrative law. So when you start impugning a legislation for being unreasonable, and in fact, it's unlikely for a legislation to be declared unconstitutional for being unreasonable, you're heading into the area of constitutional law. So administrative law is limited to the legality of an administrative decision. You cannot impugn the underlying legislation on which the administrative decision was made. So that should be clear. You cannot, if you're talking about judicial review, you do not attack or impugn the legislation itself. That is a constitutional law question. That is not part of judicial review, because judicial review is limited to examining the legality of the administrative decision. Judicial review does not involve a determination of whether or not a legislation is constitutional or legal in the first place. That is not part of administrative law. So administrative law refers solely to whether or not an administrative decision is legal or not. But you make an assumption that the law itself is already legal. So you do not impugn the law. So having said that, if you raise therefore the notion of Wednesbury unreasonableness, we assume, for example, that the law is legal, because as for those who will be studying constitutional law yet, we will know that the notion of unreasonableness is not a ground to declare, to impugn the legality or constitutionality of a law. So there is not a ground to declare a law to be unconstitutional because it is reasonable. It is the Parliament has the full authority to write as much unreasonable law as it likes. That will be valid, because it is not for the courts to, as we know from the notion of separation of powers, it is not for the courts to examine the reasonableness of what Parliament has done. If the Parliament exercises a power that is vested in it under the Constitution, because of the notion of separation of powers, it defers to the wisdom of the Parliament, and certainly will not second guess the reasonableness of any law or legislation that the Parliament passes. So it is beyond the scope of judicial review to examine the constitutionality or legality of the legislation itself, of the primary legislation itself. So having said that, the relevant question only for us is if the decision of the ABA is reasonable or not. Now, we will notice, therefore, the observation of Libby that this involves a discretion, the exercise of discretion. We will see, therefore, that when the ABA insisted on the payment of a bond of $5 billion, they were actually doing so on the basis of the law. So if they did so, can it be argued that there is Wednesbury unreasonableness in the decision of the ABA? In other words, the question is, would it actually have been open to reasonable authorities to decide that asking or insisting on a bond of $5 billion is proper or correct under the facts? Because if it can be said that reasonable authorities are likely to be able to, for some of them, to actually insist on the payment of the $5 billion, then you cannot say you have Wednesbury unreasonableness. So having said that, my answer to this question would be that under the facts, it is difficult to impugn the legality of the decision of the administrative decision maker, mainly because the decision is actually based on the law, and it is based on the exercise of discretion. And because one, it is based on the law, we assume therefore that the decision is legal, and two, because it involves the exercise of discretion, courts therefore do not have any role to play, or courts cannot examine the exercise of discretion, because then that will go into the merits of the decision. So we know that judicial review is quite limited. It is limited to the examination or determination of the legality of an administrative decision, and it does not involve trying to determine whether a decision was correct or proper under the facts, because that pertains solely to merits review. So the answer is
Manjo.
Okay. Who would like to speak first?
Sarah.
Sarah, go ahead, please.
In that case, how is this case different from the question we were speaking about, I think it was last week or the week before, where the gentleman was fired from his job for sexual misconduct, and we did examine the merits of the case in order to determine Wednesbury unreasonableness. This could be unreasonable. Francois Mills may be a very, very small company. They might not have $500,000 for a license. They might be doing something for someone else. I mean, there could be a whole range of circumstances that may make the decision very unreasonable.
Possibly, but it's unlikely. Those are two distinct facts. If we remember the scenario that we had the last time, the other scenario that we developed was that you have here an employee who had been there working for a government agency for quite some time. And because of a trivial, meaning a less offensive, possibly sexual harassment act of maybe a sexually oriented joke, you then terminate the employment of that person. Even if
it's discretionary, because I disagree with that. I would have sacked him, and I would assess this. So it is discretionary. There is options open in both cases. Right. I don't see how one case is different from the other.
Okay, but going to that case fact, you go back to the case of Edelston versus Wilcox, where the High Court has pointed out that where the administrative decision maker is actually able to use his power in a less oppressive manner, then, because otherwise, if although it's open to the decision maker, even if you can say that the decision maker actually has a wider ambit in terms of using his powers, it is important that he does not use the power capriciously or oppressively. And it can be said that the exercise of a power would be oppressive or capricious if, for example, as in the case of Edelston versus Wilcox, a decision maker uses the maximum penalty as allowed, maximum penalty as allowed under the legislation, when, under the facts, a lesser penalty would have been sufficient. So that's the case of Ellison versus Wilcox. So using that, the case of Ellison versus Wilcox to the scenario that we have, I think chances are decision makers would probably agree that if what the employee then did, I forgot the name, did was to have a trivial sexually oriented joke, which constitutes sexual harassment, it would be unreasonable and capricious and oppressive if on the basis of that sexual oriented joke, like he would say that, you know, oh, your bum looks nice. That which might be a sexual harassment. It would be unreasonable and capricious to terminate then the services of the person. So we look at the facts. So that scenario to me, I would find it difficult for a student to argue that on the basis of somebody saying, oh, your bum looks great, which might be sexual harassment, I would find it difficult to agree with a student who would then say that the proper penalty, as most reasonable authorities would agree, would be termination. I would find that difficult to agree to. Now, so having said that, yes.
Oh, sorry, Manjo. I was just going to say, so does the difference between the two situations really come down to the significant impact on the rights of an individual in the case of the sexual harassment case compared with this situation where it's a company and a corporation?
Everything boils down to the factual scenario. So there is room for an examination for the court somehow to kind of look into the merits of a case because of Wensbury and reasonableness, if possible, but that is seldom applied. So that is the exception. The application of Wensbury and reasonableness as a ground for judicial review is an exception. As we would have known by now, courts are reluctant to nullify a decision of an admissive decision maker on the basis of Wensbury and reasonableness. It seldom happens. It can only happen, for example, when there has been a capricious or oppressive exercise of power, as we saw in Ellison versus Wilcox, or, for example, there has been an unfair application or the unequal application of the law to parties who are similarly situated. So we have to remember Wensbury and reasonableness is a very exceptional instance of courts intervening or examining or nullifying an admissive decision maker. So do not look at it as a general rule. It is an exception if it is suited to the factual scenario. Now, in the problem 29 that we have, first question is, are we even dealing with a right? That's a basic question. Can it be said that Francois Mills has a right to a license? The answer is no. It's still applying for a license. Now, it would have been different if it had a license and that license were taken away. So here, it is still applied. So in terms of the factual scenario, therefore, it's different because you're not dealing with a right here. You can even say that Francois Mills has a legitimate expectation or has an interest to a license. It certainly doesn't. It's still applying for one. And so therefore, the factual scenario you had then was that you had a government employee in service for a long time. Obviously, he had a right to the employment, to his living. So look at the factual scenario, in other words, number one, and do not easily use the Wensbury and reasonableness principles to impugn a decision of the admissive decision maker. So in this case, I would argue that judicial review is unlikely to be available because the decision of the admissive decision maker is according to law. He exercised a discretion which is also within the bounds of law, and so therefore you cannot have, for example, a question involving jurisdictional error on the part, or a question of an error of law on the part of the ABA. And for that reason, because judicial review is unavailable, you can't even talk about judicial remedies. Okay, can we move on to the next one? Because I think it's 8:05. Happy with that? Let's just move on. Okay. So, problem 28. Can I have a volunteer to read that problem for us?
Yeah, I'll read it for you, Manjo. Brad.
Yes. Thank you, Brad.
Darren Wilkins operates a car rental business and has been doing most of the business accounting tasks on his own. An audit by the Australian Tax Office revealed that he had misinterpreted key provisions of the Australian tax laws and as a result was deficient in the payment of taxes in the amount of $59,000 odd. The ATO informed him that under the relevant tax laws he must pay his tax deficiency within 15 days or it would garnish all of his business and personal bank funds. Darren has come to you as a solicitor for advice. Advise Darren on the judicial remedy or remedies that are suitable to prevent the garnishment. Empty your bank account quickly.
Thank you. Okay, can I get some answers in the chat box now? Okay. So I'm just grabbing some of what's in the chat box. Okay. Oops.
While you're doing that, can I just ask about, when we have a problem, do we have to say we can apply under these grounds on common law and then under these grounds on Judiciary Act, under these grounds on the AJR?
Repeat that because I got distracted looking at the chat here. Hold on. Just going to transfer some of the answers on the screen.
Sit back, Manjo. We can't hear you when you lean forward.
Oh, sorry. Okay. Yeah, my problem really is I'm using a notebook, but yeah, I get your point. I lean back. So, sorry, B, can you repeat yourself? I was distracted because I'm trying to pick up some of the answers. There's from Erin. Mine is further up. Hold on, Erin. Let's see. Where is that? I can't find it, Erin. There's so much going on in the chat. If you could just...
Sorry, Manjo. I got my answers mixed up when I posted. I posted this one up further.
Okay. Yeah. If you, I'd be happy to pick up your answer and put it on the screen, but I'm gonna have to ask you to retype it because I couldn't find it anymore with the deluge of answers in the chat box. B, I'd like to go back to you. Yes. What was it that you said? Sorry, I missed that.
I was just saying, when we say that, do we have to go through all the different avenues of applying for a review? Like, say, we can use the common law and have these grounds under the common law, and then use the ADJR Act and what are the grounds there, and then use the Judiciary Act and what is the grounds there? Do we, in the end, have to figure out which one's the best one for our client to use?
Yeah, so that's a good point. The first key question obviously you need to answer is whether, for example, judicial review is available. And if it did, it bears repeating that your first port of call is always the ADJR Act. Okay, and the reason for that is that Parliament has actually enacted the Administrative Decisions Judicial Review Act of 1977 Commonwealth, mainly because the Parliament attempted to provide a better avenue for students to question the legality of administrative decisions, because prior to the enactment of the ADJR Act, most people would then be limited to judicial review under common law, or judicial review under the constitutional writs, or judicial review under the statutory provisions of the Judiciary Act of 1903, in particular Section 39B. But you will notice that as far as the constitutional writ in relation to the original jurisdiction of the High Court is limited to the writs of prohibition, mandamus, and injunction. Same thing with, that's also true for the Judiciary Act of 1903. in relation to the federal court, for example, again, it relates to the writs of mandamus, prohibition, and injunction. And so therefore, under the ADJR Act, we now see that there are more powers that have been granted to the courts when it exercises its powers to undertake judicial review. So therefore, in relation to your answer, the first thing you need to do, although you actually cite all the possible sources of law to ground your application for judicial review, your basic, if the ADJR Act is available, then you ground your application for review under the ADJR Act, if you could. Because the reason for that is whatever powers have been granted to the courts under the ADJR Act are also available under the Judiciary Act. So in other words, why bother citing the Judiciary Act if you can use the same powers as provided under the ADJR Act anyway? So the Judiciary Act, for example, becomes kind of superfluous if you can already ground an application for judicial review under the ADJR Act. But because we know that the ADJR Act only is applicable in a situation where an administrative decision is based on an enactment. So in the event that you have an administrative decision that is not based on an enactment, because it could be, it can involve the exercise of a prerogative power, or it may be because too, the decision maker actually is not a public authority, although it may be undertaking public actions or activities, such as you can have a private company that is responsible for collecting garbage or for getting involved in telecommunications. It's providing a public service, but it is not a public government agency, therefore not acting on the basis of an enactment. Then the ADJR Act might not apply. Or it might be that a government agency is exercising its powers not on the basis of an enactment, but on the basis of a general law, such as the General Law of Contracts. In that case, the ADJR Act will not apply. And because the ADJR Act will not apply, then that's when you examine the possibility of the application of the Judiciary Act of 1903, for example, or the common law judicial review. But in general, you always begin by asking yourself the question, would the ADJR Act apply in this case? Because if it does, you will be better off arguing on the basis of the application of the ADJR Act. You could still argue the application of common law judicial review, but that is superfluous. You should do both, just to be sure. But if you know that the ADJR Act applies, then apply the ADJR Act in the first place.
So I thought I read somewhere that the ADJR Act may not apply in some areas of taxation.
That's right. That's correct. So that was the point I was making. You need to figure out, because there are exclusions under the ADJR Act. If it might be an excluded decision, because, for example, it's one of those where it involves the exercise of the power, for example, by the Governor General, then the ADJR Act will not apply. So you try to determine if the ADJR Act is applicable. Look at the exclusions, because if it is applicable, you use the ADJR Act to grant your application for judicial review. But if the ADJR Act is not available, or cannot be applied under the facts, then you wish to consider if, for example, Section 75 of the Australian Constitution can be applied by resorting to the original jurisdiction of the High Court, or you want to examine Section 39B of the Judiciary Act of 1903 Common Law to determine the jurisdiction of the Federal Court of Australia in relation to writs of mandamus, prohibition, and injunction. And if you feel that they're inapplicable because the writs of prohibition, mandamus, and injunction may not be sufficient remedies to address your legal problems, then you wish to examine whether common law judicial review might also be pertinent.
Oh, Manjo, just on what you said about prohibition, mandamus, and injunction in line with 75.
Section 75.
Yeah, 75.5. If the remedies weren't one of those three, you could also, couldn't you then tackle that or seek remedy via 75.3?
That's right. You also could. And
Thanks.
so when the Commonwealth, for example, is a party to a proceeding, you can certainly look at Section 75(3) as well of the Australian Constitution. But in that case, you will notice that you're looking at the original jurisdiction of the High Court. And it is not often the case that the High Court will entertain an application for judicial review. It is like, assuming that you went up to the High Court, it is likely to remit an application for judicial review to the Federal Court of Australia if it feels, the High Court feels that it does not involve a very important legal principle or question of law. Okay, so moving on. So where are we now? So hold on, I'm just trying to see here. So let me just look at some of the answers that have been. Oops. So we've got another answer here. This is from B. Interlocutory injunction followed by prohibition. Well, okay, maybe that will be sufficient for now. I'll also pick up the one from Michael. And that, that should be sufficient for the purpose of trying to proceed with this discussion. Okay, let's see. So let's deal with the first question first. Is judicial review available? Before we talk about remedies. What is the ground for judicial review? Before we talk about judicial remedies. So there's an answer here. It sounds oppressive. Sounds like unreasonable is brewing. Okay. So before we talk about judicial review remedies, so even if you have a question such as this, so even if you have a question such as advice therein on the judicial review remedy or remedies that are suitable to prevent the garnishment, you always have to go back to the basic question of whether or not judicial review is available. And so you begin by asking yourself, or trying to figure out whether or not this involves a question of law. Now, even if it does involve a question of law, you always have to find out what is the ground for judicial review. Because without the ground for judicial review, you don't talk about remedies. You only talk about remedies to determine that, assuming that the court can have jurisdiction to entertain an application for judicial review, and assuming that there is a ground for judicial review, you then need to determine whether or not there is a remedy that is available that will resolve or sufficiently address the legal problem that you have. So going back to the first two questions, does this involve a question of law? And two, is there a ground for judicial review? And then we will discuss remedies. Would somebody care to use the mic?
Manjo, I actually put section 5E of the 1E of the ADJR, that the making of the decision was an improper exercise of the power confirmed by the enactment, and then an exercise of discretion, and then 2F, an exercise of discretionary power in accordance with the rule or policy without regards to the merits of the particular case, as well as maybe 2G, that's so unreasonable.
Okay. So I'd like to point out something there. So thank you for that, B. Again, it is crucial that you provide later on, if there were an assessment, you need to be able to justify why you think these provisions are actually relevant to the factual scenario. So that's crucial there. But again, before we do that, we go back to that basic question first. Does this problem involve a question of law? Does it involve the legality of the decision? Why is that? Which obviously is linked to the question of whether or not there is a ground for judicial review. Why would this be a decision that seems to be unlawful or contrary to law? That is what interests me for now.
Manjo, I saw this case very similar to the Edelsten case.
Yes, go on.
Basically, where it was a use of capricious and oppressive use of power, which is unreasonable and invalid.
Why?
Well, the Commission of Taxation, with its Special Obligation Section 128 of the Income Tax Assessment Act does not give authority for it to become an instrument of oppression, to be used for a collateral purpose of extorting money from other sources by making it impossible for the taxpayer to continue to earn his living by the ordinary conduct of his business or profession. Now, that was from Edelston and Wilcock.
Yes.
And then it goes on to say that when they're reviewing these things, the courts will actually proceed with restraint. Darren has at his disposal the possibility of a review for this decision under the common law or the JR Act, Section 39B.
Okay.
As I thought, that had been a breach of natural justice.
Very good.
And he'd been prevented from obtaining a fair and unbiased hearing, particularly before decisions were made which had serious consequences to his ability of making a living. These actions, or lack thereof, render the decision necessarily unreasonable.
Well done. Who was saying that again? Sorry, who said that?
Aaron.
Well done. Thank you, Aaron. So obviously, Aaron has pointed out that there are grounds for judicial review because they involve questions of law. The first one was because it seems to be an oppressive and capricious use of the power, and citing the case of Edelston versus Wilcock. That's good. Secondly, there's also the question of a breach of the rules of natural justice because the exercise of the power by the ATO seems to involve the garnishment of monies belonging to Wilkins without providing him the opportunity to contest the decision or the order of the ATO. So there's a breach of natural justice. Good. There's actually a third ground. Would somebody know what it is?
Can I just bring up Manjo? It's Aaron again. I also drew on Castlemaine Tooheys Limited in South Australia, 1986, 161 Commonwealth Law Reports at page 148, where Mason pointed out that the seizure of a person's asset violates a legal or equitable right, which may attract a prohibition. However, this remedy is discretionary and may result in refusal, particularly if there is a means of internal review or if the matter has been heard and decided on.
Very good.
So from that, I drew the conclusion he had 15 days, and I would have advised him to seek an internal review if available, and failing that, he would need to apply for an interlocutory injunction until the matter was heard.
Okay, let's talk about the case first, and then we'll talk about the 15-day review that you were saying. So we do have a case, the Castlemaine Tooheys case, which is to the proposition that where monies of a person are about to be garnished, then it's possible to seek recourse of the courts by asking for a writ of prohibition. Okay, so that's fine. So you've got another ground, and I'm going to go back to the internal review of 15 days in a short while. The other question, so far we've identified three possible grounds for judicial review. The first one being that obviously it involves a question of law because there seems to be an oppressive exercise of the power, citing the case of Edelston versus Wilcock. Secondly, we seem to see a breach of natural justice. And thirdly, following the case of Castlemaine Tooheys, Castlemaine versus Tooheys, it would appear that this involves the unlawful garnishment of monies that belongs to a litigant. So we've got three grounds. The fourth, is there a possible fourth ground for an application for judicial review on the basis of the possible illegality of the administrative decision?
Does the Act provide for an external review?
Is that an answer? Is that an answer to my question, or
the administrative? What is it? The AAT.
ATO.
Would that be the other avenue? Whether the Act provided for a review through them?
The fourth possible ground really is that you will notice that Darren Wilkins operates the business, so there's a possibility that the business that he operates has actually been established as a proprietary limited company. And if it were a proprietary limited company, it would mean that his business therefore has a distinct and separate legal personality from that of Darren Wilkins. If so, if the company of Darren Wilkins has a separate and distinct legal personality, and it is that company which has a tax liability to the ATO, then it would be unlawful for the ATO to issue an order of garnishment over the personal funds of Darren Wilkins, because Darren Wilkins does not owe anything to the ATO. That would have been a fourth ground, which obviously is not really part of admin law. I'm just saying that, if you look at corporation law later on, you will realize that if you have a proprietary limited company, the proprietary limited company has a legal personality that is separate and distinct from the owners of the company. And so therefore the liabilities of the company are not the liabilities of the individual owners, and the liabilities of the individual owners or their assets are not the assets or liabilities as well of the proprietary limited company. So that was just a fourth ground. So having said that, we now are in agreement that on the basis of 4 grounds for judicial review, which all involve questions of law, an application for judicial review is available. So we've agreed on that. Having done that, we now address the question of what judicial review remedy or remedies are suitable to prevent that garnishment. So we're now going to the question of remedies. And it's actually 828, but we'll extend. So let's see. In this, so let's go back to the point raised by Erin, was it earlier? Who was asking, so Erin, I think it was Erin who made the point that before you can apply for, let's say, before you can apply for a writ of prohibition, or maybe a writ of injunction even, it is necessary that you must first try to seek an internal review where it is available under the law. Okay? The first question we have is, why is that necessary? So in other words, if the law were to provide for an internal review as a remedy, why is it necessary for an applicant then to first exhaust that internal review mechanism before he or she can apply for judicial review?
Well, they have to exhaust all avenues before they can go to the courts to seek a remedy.
Because?
I think I read at one stage, I don't know if this is the correct answer, that the courts have got enough on their plates without being cluttered by other things where people have got internal reviews they can seek to resolve their issues.
Okay. Let's just examine that point further, because that seems to be an interesting point. Just to clarify, are we suggesting that before, for example, one can apply for judicial review under the ADJR Act, if an enactment provides for an internal review mechanism before one can apply for judicial review under the ADJR Act, the person must first exhaust the internal review mechanism? Is that correct? So following on what you just said.
From my memory, Manjo,
yes,
they can still apply, but the courts have the discretion to refuse the application if all other avenues haven't been exhausted, and I can't think of the actual section of the ADJR Act that specifies that.
Is that a requirement actually? If there's an internal review mechanism, then the courts will necessarily refuse to undertake judicial review?
Not that they'll refuse, but that they can choose to refuse.
That's right. So there's a question of jurisdictional requirement versus one that is not. That is a crucial point, because even if an enactment provides, for example, has a mechanism for judicial review, and an applicant does not apply for that internal review, it will not bar an applicant from applying for judicial review under the ADJR Act, assuming that that avenue is available. Okay, so let me repeat. Even if an enactment that had been the basis of an administrative decision provides for a mechanism for internal review of an administrative decision, assuming that an applicant who is aggrieved by such a decision does not wish to seek recourse for internal review and instead applies for a judicial review under the ADJR Act, the court can still accept that application and still undertake judicial review, notwithstanding the fact that the applicant has not applied for internal review. Now, So the question is then, is that rule the same as far as writs of prohibition, mandamus, or injunction are concerned, or common law remedies are concerned? So as far as judicial review remedies under common law principles, or even the Judiciary Act of 1903, for example, is it also true that even if there is an internal review mechanism that is in place, a person may still decide not to apply for an internal review, and instead apply for judicial review and seek judicial remedies under common law principles, for example, notwithstanding his or her failure to seek recourse under internal review mechanisms. What is the answer there? So the answer from Vicky: court has discretion to refuse relief for applicant has failed. That's right. Okay, good. Good. So let's make a distinction. As far as an application for judicial review is concerned, and as far as seeking judicial remedies under the ADGR Act is concerned, it is not necessary for an applicant to seek an internal review of the administrative decision, even if the Act provides for such an avenue for internal review. It will not prevent a court from undertaking judicial review on the basis of the ADGR Act, even if an internal review mechanism is available. However, if the application for judicial review is grounded on common law principles in general, an application for judicial review on the basis of common law, and therefore recourse to judicial review remedies for writs of prohibition, mandamus, and injunction are likely to fail if there is an internal revenue mechanism. If an internal review is available, meaning if you can appeal from an administrative decision to the original administrative decision maker, and you did not, as an applicant, exercise your power, your rights within under that enactment, then the courts are likely to dismiss your application for judicial review. So what we need, hold on, let me just finish this. So what we need to remember is that whereas a person, an applicant, may have powers to seek recourse for judicial review if it's available under the ADGR Act, recourse to common law judicial review is discretionary, and courts are likely to not accept an application for judicial review based on common law principles if there is a mechanism for internal review or an internal appeal of the administrative decision. Yes, so what was the question?
Sorry, Manjo, I couldn't get to my microphone button. My question is, does that also relate to the availability of merit review? So if merit review were allowable under the legislation and that had not been availed of, would the courts also be less likely to grant judicial review?
Hold on, wait. I did see the connection there. You're talking about merit review and then talking about judicial review. What exactly was the factual scenario there?
So my question was, if you had a set of facts and you had the possibility of both judicial review and merits review, but you had chosen not to undertake merits review, is it likely that the courts would exercise their discretion to not grant judicial review because for want of a better description, lower levels of review and the cheaper option of review hadn't been availed of?
No. For as long if it is open to the applicant to actually apply both for merits review and judicial review, and the courts will see that there is a proper basis for a judicial review because it involves a question of law, then the fact alone that merits review is available is actually kind of irrelevant, Because remember that a merits review looks at a review of the merits of a decision. It does not actually involve a determination of the legality of an original decision maker's decision. So therefore, if you're grounding your application for judicial review on the basis that an administrative decision is unlawful, then the proper remedy is actually to seek judicial review. So the proper question is, given a set of facts, does this set of facts involve a question of law, or is it a question of facts? Does it involve the legality of the decision, or are you impugning the decision on the basis that the merits of the decision seems to be incorrect or improper? So those are two distinct things. That's the basic question. If the question involves a question of law, then obviously you need to seek recourse under judicial review. If it involves merits, if a merits review is available under the enactment, then you go for merits. But those are two distinct, factual scenarios. So that is,
thank you so much for clarifying that. Thank you.
Yes. Now, any other questions? So, okay, I'm having trouble. Okay, so from there, what about under both law and fact? Now, so I see what you mean, Aaron. So as we know, even if a merits review, for example, by the AAT, generally looks at the merits of a decision, we do know that in the case of Collector of Customs, New South Wales versus Brian Lawler Automotives, we do know that the mere fact that an application for merits review actually touches upon the legality of a decision, that alone will not debar the AAT from exercising its jurisdiction. So in other words, when a merits review is undertaken, the AAT actually looks both at the merits of the decision as well as the legality of the decision. So when the AAT reviews a decision of an original decision maker, it actually looks at the merits of the decision, whether or not it is the correct or preferable decision, but at the same time, it seeks to determine whether or not the original decision maker, when it arrived at the decision, was deciding it according to the law. Okay, so there is, in fact, in the merits review, an appreciation or an examination of the legality of the decision, except that anything that the AAT may say on the legality of the decision is not conclusive. Neither is it binding upon the parties, because questions of law always belong solely to the courts. But having said that, what it means is that the mere fact that a merits application or merits review application may involve a question of law will not mean that the AAT no longer has jurisdiction over the case. For as long as the basic purpose of the merits review is mainly still a review of the merits of the decision, meaning based on the facts of the case, whether or not the decision was the correct or preferable one. Okay. So we're just going to go through this quickly because it's now 8:45 and we're really running out of time. So just to clarify, so if the ADJR Act is available, you seek recourse to the remedies available under the ADJR Act. Now, if the ADJR Act is not available, mainly because perhaps the decision does not involve an enactment, or because the decision is not based on an enactment, because it is based on general laws such as contracts, or it may be because the original decision maker is not actually a public authority. So as I said, you might have a private agency undertaking public functions. In that case, again, the ADJR Act will not apply. So assuming that the ADJR Act will not apply, then you wish to determine whether or not common law judicial review is available, or review under Section 39B of the Judicial Act of 1903 might be available. So we're clear there. So what I've said so far is that you've got statutory judicial review remedies under the ADJR Act and also under the Judicial Act of 1903, but you also have judicial review common law remedies. And in that case, you can speak, for example, of prohibition, mandamus, or mandamus, or you can speak of habeas corpus. So those are common law judicial review remedies, but they're also equitable judicial review remedies. So I'm just kind of doing a background here, mainly because I haven't come up with a lecture video yet. So the point being that how do you distinguish common law judicial remedies from equitable judicial review remedies? The main distinction is that if you look at common law judicial review remedies, there are actually certain requirements that typically have to be met. So, for example, if there is a requirement for there to be recourse to common law judicial review remedies, that the decision maker, for example, is a public authority or is exercising a public power. There is also a requirement, for example, that it must involve that the application must involve the violation of clear rights of the applicant. On the other hand, what it means is that under the equitable judicial review remedies emerged mainly because of the rigidity of the common law judicial remedies, in the sense that, for example, one, if the decision maker is not a public authority or has not exercised a public power, or, for example, the applicant may not have exercised possible internal review appeals, because that is a requirement for a common law judicial review remedy, that if there were available internal review appeals, it is necessary that the applicant must first have exhausted that. So if the applicant does not, because common law judicial review remedies are discretionary, then chances are the court will dismiss the application for judicial review. On the other hand, if you're speaking of an equitable remedy, and the reason why it's called equitable, because it seeks to provide an equitable remedy, or it seeks to provide remedies to an applicant given the rigidity of the requirements of the common law, it means, therefore, that it is possible for an applicant to apply for equitable remedies in judicial review, even if the decision maker may not actually be a public authority or may not actually be exercising a public power, or, for example, even if the applicant may have failed to avail of internal review mechanisms that are available under the law. So can you see the distinction now? Now, having said that, the question then is, what is the possible available judicial remedy here? So, yep. So having provided an explanation, it would seem that, okay, so let's look at the first answer here, an overlap between the remedies of certiorari and prohibition. Can we just examine what is the distinction between the two? What is the better remedy between the two? Certiorari and prohibition. If you were the lawyer, if you were the solicitor, would you advise certiorari or prohibition? Are they the same? Can somebody answer that? Certiorari or prohibition, are they the same? Okay, because we're kind of running out of time, and I think that some people are dropping out. Let's just kind of clarify this now. Unless, okay, not the same, unless somebody wants to use the mic. Okay, yep, so we should be going for, yes.
I was going to say, Manjo, I read somewhere certiorari, or however you pronounce it, is not always the best remedy, but I can't remember the reason what was given. Yes.
So that's right. That's correct. So prohibition actually would be the better remedy here. Would actually be the better remedy here if it were available, and not certiorari, because the effect of a certiorari actually is to quash a decision. Okay, but under the facts, there is now an attempt on the part of the ATO to garnish the funds. So if what you do is to apply for certiorari, that may take a while. It may take a while, in other words, for a court to, it may actually take a while for a court to resolve that application, to quash the decision. And in the meantime, your funds get garnished, which means, therefore, that your business can't run. So therefore, although declaration, that certiorari would have been a possible remedy under the facts, it is not a suitable option. How about prohibition as opposed to interlocutory injunction? So interlocutory injunction is an equitable remedy. or in particular a prohibitory interlocutory injunction. What is the difference between prohibition and a prohibitory interlocutory injunction? What is the difference there?
Well, prohibition means that the court can issue a writ to restrain further unlawful action or from them exercising the power to take his money or business.
Yes. So prohibitory, a writ of prohibition would have been available, but it may not be swift enough. Because the writ of prohibition will only be issued when the court arrives at a decision that the original decision of the decision maker is actually unlawful. That can take a while. It might be too late. So what you're looking for as a solicitor is a judicial remedy that is quick and stops the ADO from enforcing its order or acting on its order. So therefore, the best remedy would be an interlocutory prohibitory injunction, because as Vicky pointed out, it will be heard more quickly until a further decision can be made. Well, if you go through I will not go through the what have to be met in order to have the interlocutory prohibitory injunction. You'll see it, but the correct remedy here will be that it should be applying for an interlocutory prohibitory injunction, which is an equitable remedy. And from Brad, so I'm just reading what Brad now says. Oops, where's that? From Brad. So I encourage those who are watching the recording to go through the chat box, because there's a lot of good information here. From Brad Marler, prohibition, on the other hand, has a largely negative effect. It prohibits the impure decision maker and those relying on the decision from doing something illegal which they're about to do, or from continuing an illegal course of action already commenced. Accordingly, the main difference between certiorari and prohibition is the timing of the application. Okay, so yep. So from Michael, for there to be a prohibitory, for the interlocutory prohibitory injunction to be available, that there is a serious question to be tried, or that the plaintiff has made out a prima facie case, in the sense that if the evidence remains as it is, there is a probability that at the trial of the action, the plaintiff will be entitled to relief. 2, that you will suffer irreparable injury for which damages will not be an adequate compensation unless an injunction is granted. And 3, the balance of convenience favors the granting of the injunction. So thank you, Michael. So that's it. In relation to the answer, therefore, advise Darren on the judicial remedy or remedies are available. Apply for the equitable judicial remedy of an interlocutory prohibitory injunction based on the explanation that I have just previously given. It's now 8:50. Any questions before we end tonight's session?
I have one question, Manjo.
Yes.
With regards to the exam,
yes,
is it going to be based on the whole of the course material or only on the second half of the course?
I will give a better answer to that, because that's still quite broad. My answer will be that in the revision, I am likely to point to you a general topic that you should be reading on.
Okay,
so
thank you.
I'll give you specific areas to actually prepare for. And in addition, the kind of questions I'll be asking in the final assessment will be similar to the kind of problems that we've been having.
Okay, thank you.
Okay, so I guess that should be it for tonight. Thank you, everyone, for actively engaging in tonight's tutorial, and I hope to see you again next week.
Manjo, Manjo, just before you go, I did put a thing in the chat box. I couldn't really hear a lot of what you were saying tonight, so I hope we're going to get a written response to those tutorial questions from you. Are we?
Yes, you are. You are. I will post the written answers next week. I can't do it now because I'm still giving students an opportunity to answer the tutorial questions as part of the online group discussion assessment. But after next week, I will post the written answers. So thanks everyone for really engaging in tonight's session, and I look forward to engaging with you again at next week's tutorial. Good night, everyone. Bye.